When it comes to IRAs, the funds that are accumulated in it, tax deferred, are usually intended to be used for funding retirement after age 59 and a half. Because of that, there can be penalties for early distributions from an IRA. But there is a way you can avoid this penalty through substantially equal payments made from the IRA over your life expectancy. This is a presentation for attorneys and advisors who want to understand some of the nuances to IRA distribution rules and individuals who might contemplate making early withdrawals from their IRA and who wish to discuss this with their financial advisor. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. Today's episode 225, is all about substantially equal IRA distributions. We're going to briefly skim the surface of some of the guidance out there, including Revenue Ruling 89-25, which gives us a little more meat to how do we actually calculate substantially equal IRA distributions, because there's no guidance in the code or the regulations as to how you might get there. As always, I remind you that this presentation is not intended to substitute for legal or tax advice. It is provided for educational purposes only. And if you would like to retain me as a speaker, you can email me at griffin.bridgers@gmail.com. Now on to the presentation. So, there's been a lot of talk in the news lately about accumulation of significant amounts of wealth in both Roth IRAs and traditional IRAs. And the problem with that accumulation of wealth is that it's tax deferred or tax free in the case of a Roth, but regardless of what form of IRA you have, you can't take anything out of that IRA until you reach age 59 and a half. So if you do take an early distribution, then generally there's a 10% penalty that's assessed on the amount of that distribution under Code Section 72T. Now, there's a lot of exceptions to that. I've covered a couple in the past. I won't mention those by name, but really what today is about is another exception to that general rule where that penalty is imposed for an early distribution. And that is where there's a distribution made from an IRA as part of a series of substantially equal payments that are made over the lifetime of an employee or owner of an IRA, or over the joint lives of the employee and a designated beneficiary. So this substantially equal payment exception can be great. It can give you the way to get IRA funds out early. But the problem is once you start, you can't stop. So what is our starting point for getting there? Well, as I mentioned, you can't stop and you can't go about this haphazardly once you make the decision to go down this path. So what often goes wrong is the failure to pick a method of how you're going to calculate substantially equal payments and stick to that method. So for example, there was a tax court case of Graham versus Commissioner where the owner of the IRA, starting at age 51, just started taking random early IRA distributions of varying amounts every single year. And he wasn't really the one calling the shots. Instead, he was relying on his financial advisors who were really taking the IRA distributions out for him and then telling him that those satisfied that exception for substantially equal payments. But the spoiler of the case is he did not. Simply relying on his financial advisors wasn't enough to get him there. Neither the taxpayer, Mr. Graham in this case, nor his financial advisors could show to the IRS that there was any method chosen that had been blessed by the IRS or even any documentation. It was more that they got caught after the fact just taking early IRA distributions, or it looked that way, and then they tried to claim that, oh yeah, we were trying to follow this substantially equal payment exception, but that wasn't the case. So there is a 10% penalty applied to the early IRA distributions. So simply being told you're in compliance is not enough. That's the lesson here. You need to be able to pick a method to calculate the payments and document that you followed this method year in, year out. And that being said, there are some specific methods blessed by the IRS under Revenue Ruling 89-25. Now, it's important to note that once you start down this path, you're committing to this for life. You have to take out distributions at least annually once you commit to early distributions that use this method. So the easiest way to go about this is just to use the life tables that you'd use for an IRA, maybe after reaching age 59 and a half, or for an inherited IRA. We'll talk about that in a minute, just because the tables out there may not universally apply. So, when you're looking at this, you need to make sure that you stick to the distributions, that you don't stop them, and that you don't exceed them. So the methods are kind of beyond the scope of today's discussion, but you can use just the IRS basic tables. That's the easiest way to figure out what your life expectancy is and take distributions based on that life expectancy. Now, this revenue ruling blesses a few other methods if you're into financial modeling, where you can use an amortization method or an annuity factor method using some assumed interest rate and calculations. Now, those calculations don't necessarily use the same calculations we've talked about in prior episodes with annuity factors under the IRS tables for estate planning. It's a whole different world and a whole different methodology used for those, which is why we're not going to dive into them in great detail. But here's a quick example. This is just kind of a quick back of the napkin. We have a client who's 39 years old and single, and as of the close of the prior tax year, he had accumulated $2 million. So looking back to December 31 of 2020, his IRA balance was $2 million, and he wishes to retire early now, but without incurring the 10% penalty. So the client would then use the single life table to determine the distribution period based on the client's life expectancy. So for age 39, the life expectancy is 44.6 years. So essentially we divide 2 million by 44.6, and we get a distribution of $44,843 that the client can take out this year, penalty-free, as long as he commits to starting that process and taking those distributions every single year based on that same calculation method for perpetuity. So here's some other tidbits. One, you run into an issue where I mentioned that if you start this, you have to commit. So distribution should keep using the same method. If there's a substantial modification within 5 years, or if later, before you reach the age 59 and a half, then the penalty applies in the year of the modification for the excess distribution or to the amount you should have taken out. Now, there's a lot of other exceptions to the penalty for early distributions, things like the coronavirus-related distribution for 2020, which I've talked about in the past, and things like birth and adoption expenses, home purchases, hardship distributions, so on and so forth. If you commit to this method but later on also qualify for a different exception, you need to look into the exception more, because that exception may not be treated as a substantial modification. So it may allow you to take out more than just that life expectancy distribution every single year if you have a special life event that would substantiate it. Now, when you're calculating required minimum distributions, oftentimes you would use the uniform life table, but you cannot use that here because it only kicks in after age 72 for purposes of calculating required minimum distributions. So you typically need to go to like the single life table or the joint and survivor life table based on difference in age between the IRA owner and spouse. It's important to note too that this penalty does not apply to inherited IRAs. Instead, the inherited IRA has required minimum distributions that kick in immediately, regardless of the age of an individual beneficiary, but subject to the Secure Act, which may require a showing of eligible designated beneficiary status to qualify for lifetime distributions. Now, if you do qualify, the calculations may be the same here for an inherited IRA or an IRA where you want to use this substantially equal payment method, but with some exceptions as we looked at for a greater calculation based on an interest rate under Revenue Ruling 89-25. Now finally, it's important to note too that if there's a waiver of the required minimum distribution for the year like we saw in 2020, that waiver doesn't apply to the substantially equal distributions. You have to keep taking them out to avoid that modification and to avoid the penalty kicking in. Once you commit, you cannot quit. And that's all I have for today. As always, if you have questions or topic suggestions, you can email me at griffin.bridgers@gmail.com. Please note that I cannot provide legal or tax advice or advice on completing tax forms, so please don't email me about that. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.